The Court of Appeals for the 4th Judicial Appellate District is now open pursuant to call.
Good morning. Please be seated. The court will now call cause number 0422-130 CV, Consolidated Towne East.
Yay, oh yay, oh yay. The Court of Appeals for the 4th Judicial Appellate District is now open pursuant to call.
Let's start over. The court will now call cause number 0422-130 CV, Consolidated Towne East Holdings LLC versus the City of Laredo, Robert E. Eads in his official capacity as Office of City Manager, and et al. Announcements, please.
Your Honor, Rick Thompson for Appellant CTEH.
Morning.
Brian Henry for the defendants, Your Honor.
Good morning. Each have been apprised of their time, and counsel for appellant may approach and proceed.
May it please the court. After months of CTEH negotiating with the city to purchase living unit equivalents, which I'll call LUEs, which are necessary for development in the ETJ, and getting my microphone went off. Oh, there we go. The city suddenly announced that they would not sell any LUEs to CTEH unless CTEH agreed to voluntarily annex their property to the city and pay hundreds of thousands of dollars in annexation fees. Now, no city ordinance or contract requires CTEH to pay these fees, but the city points to their participation agreement with 8 other landowners, which doesn't apply to CTEH, and they argue that annexation was always required in order to receive water and sewer services. Well, that's just not true, but the city's agreement with them has no impact or bearing on CTEH. The city received over $16 million that they don't have to pay back to develop this area and provide water and sewer services. The position is that they're only required to give 1 water and sewer tap to each tract of land. So that means CTEH gets 3 for 26 acres in the colonias. They have gotten those 3, but they want to develop the property and get 72 residential units. Because of that position, though, the city contends they can condition that sale on annexation, or I guess any other condition they erect to the sale of LUEs. That's improper. That's the definition of an unconstitutional exaction, and that's a regulatory taking, and that's why we're here. The trial court granted summary judgment to the city. We believe it's wrong and it should be reversed and vacated, and judgment should be entered for CTEH. Now, regulatory takings, this is an unusual one because it's an exaction, which means they condition either a plat approval or property approval or some kind of development on the landowner agreeing to do something that's not required or more than usually required. And that's what we have here. So to determine whether or not that exaction was unconstitutional, and not all of them are, but to determine that, we have to review whether or not the city proved 2 things. Because although this is our cause of action, we proved an exaction, then the burden shifts to them to prove that it's not unconstitutional. They have to show 2 things. That's an essential nexus between the annexation and a legitimate government interest. And if they show that, then they have to show that the exaction is proportional to what the impact would be of the development.
Mr. Thompson,
Yes,
before
ma'am.
we even go there, first, the plaintiff, or CTEH, has to show an exaction. So it has to show that it is a cost. The city is trying to impose a cost or a condition that, in fairness and justice, should be borne by the public, not CTEH. Is that correct?
That's correct.
So tell me what proof CTEH has, or what its proof is to show that this is, unfair and unjust to require CTEH rather than the public. Well, let me back up, because we know that this is an extraterritorial jurisdiction, right?
Yeah. Yes, ma'am.
It's outside of the city limits. And so the city has gotten federal and state funding, and I think the city took out a loan as well. And then the ordinance is specific to the colonias, right?
Yes, Your Honor.
They're going to develop and provide sewer and water lines to the colonias. So, and it's my understanding from reading the record that your client intends to develop the land that will not be a colonia. Is that correct?
No, Your Honor, that's not correct. It is in a colonia.
Okay.
What the city is arguing is that we're not erecting colonia-type housing.
Mm-hmm.
That would be housing that would be not allowed under any jurisdiction because it's improperly sewered and water, and it's a poor area that's really substandard housing. We could not develop substandard housing in the area, but to claim that it's a non-colonia development is not correct.
Okay, so back to my question. Can you tell us what your proof is to show that in fairness and justice, this expense should be borne by the public and not CTEH?
Yes, Your Honor. Like any other provision of services, those are normally borne by the public, unless a statute provides specially that those persons should bear the cost. And here we don't have anything like that. We have some landowners who contributed to the original project to fund extra large pipes to the area so that there could be future development. But there were 8 developers, and they paid $800,000. They're asking CTH to pay $250,000 or more for their LUEs, and those LUEs, the annexation is above and over what the LUEs are. The LUEs are what makes it fair, because that takes into account the water usage, the sourcing of the, burden on the piping system, and the city's, processing plants and all that kind of thing. All of that is taken into account when we buy the LUEs. But in addition to those thousands and tens of thousands of dollars in LUEs, they're asking us to pay $250,000 on top of that, which has no relationship whatsoever to the provision of water. There's not even proof that it goes into the water system. I think it goes to the general funding account, but there's no evidence either way.
Annexation address something different? Thank you. Doesn't annexation address something different than the LUEs?
Absolutely.
Okay, because we know that annexation concerns more just adding property to the tax rolls for the purpose of maintaining city facilities and services. And the LUEs concern more the repayment of costs associated.
Yes, Your Honor.
So with the oversizing utility lines particularly after several colonial landowners had elected to oversize their lines. So tell me how this addresses the rough proportionality test.
Well, that was the city's burden, and there's absolutely no evidence of what the original 8 landowners paid or what anyone else pays in the record versus what we would pay. There's no evidence of what kind of burden our development would add to the city's budget or water and sewer system budget or anything like that. There's just absolutely no evidence. And because of that, they can't show that this is constitutional. Did I answer your question, Your Honor?
Well, I'm wondering whether or not, sometimes I think that the briefing it's almost like y'all aren't talking to each other, right, on the same issues. So how is a full analysis possible if you've not actually applied for annexation?
We're not required under the constitutional law of the United States Supreme Court to actually go through with the application process and be denied or annex our property and then complain or anything like that. The threat of the annexation alone under the case law is sufficient to trigger the cause of action.
Yeah, the Texas Supreme Court has given us some guidance on this in Town of Flower Mound. If the Supreme Court requires that the government first, quote, make some sort of individualized determination that the required dedication is related both in nature and extent to the impact of the proposed development, does that make Consolidated's complaint as to the estimated costs premature?
No, Your Honor, it does not.
How so?
Well, we know, and it has been estimated by the city, and an affidavit was put into evidence, that we already know it's going to be at least $225,000 up to $350,000 for these fees. And if we were required to do that, they could have estimated what other people pay or what the burden to the city was and weighed those out. There's just no evidence. That's not our burden to prove.
Is that evidence, though, simply focused on water services? Or is there other additional factors considered? Because the analysis as to proportionality, would that not, under the Supreme Court ruling, require consideration of all aspects of the development plan, not simply the water services?
I think the service that was denied was simply the LUEs and the water service. If there were other costs associated with it or other burdens to the city, those could be proven. I don't know what those would be, honestly, and there's nothing in the record for it.
Very good.
So I think the key here is that the burden was on the city to prove that it was constitutional, and they simply failed to do so after we showed that this was a cost that would not otherwise be borne by the landowner. Now, with respect to the essential nexus to a legitimate purpose, the city makes two arguments. The first is that they need CTEH to annex in order to share the tax burdens of the water services. But as they later admit in their brief, the LUEs take that into account. So that's not a separate, that's no reason to require annexation because you have the LUEs. And the second is that they say that they were required to do so by Texas law. And again, the problem there is that the definition of the project morphs throughout the argument. It's not just the project with the state, because nothing in the state project between the city and the state or between the Webb County and the city requires annexation. They are saying that we would get an unfair benefit because the statute does say, 17.936 says that no developer should get an undue benefit. But again, there's been no showing that we would receive an undue benefit because there was just no evidence to prove that. And again, none of those statutes and none of the contracts that are actually applicable to us require annexation. Now, the original landowners did agree to annexation, but we don't know what those negotiations were or why they agreed to annex, because clearly that's not part of the record. But there was nothing in that agreement that required future landowners to get the exact same agreement that the original 8 landowners did. With respect to proportionality, the city simply says that it's difficult to analyze because we didn't apply and they didn't get the costs, but there was an estimation of costs and there was simply no evidence of what the cost to them would have been.
How do you address then the city director of utilities who by affidavit provided an estimation of costs?
Yes, Your Honor. I'm sorry, I didn't hear the first part of your question.
The record indicates there was some evidence from the city director of utilities that
Yes.
provided an estimation of the cost, additional cost to annex. does that not amount to sufficient evidence?
That's some evidence of what the burden would be to us, but not what the city's burden would have been. It was just an estimate of what our costs would be. There has to be a comparison of what the costs were to us versus what the impact would be to the city and the costs and burden to them. And that's where the proof fails. There are some arguments about limitations, but and there's also an argument that this is not a taking because it involves services. The services argument is based on the Supreme Court's ruling in Schrock, but in that case, that was a failure to pay your water bill, and so they withheld the provision of services. This isn't a withholding of services because of, failure to pay. This is a denial of the right to develop land. Now, although water is the underlying service, this is not a challenge because we are not receiving water. This is a challenge because we are not receiving the right to develop our land. And that's a land use regulation, pure and simple. With respect to limitations, there really isn't one because our claims are that these officials acted ultra vires, and ultra vires acts are void. So no statute of limitations applies, but if one did, it would be the takings regulation, which is 10 years, not the 2 or 3 years that they rely on. And I guess finally, there is an argument that we were required to notify the city of our claim and that we failed to do so. But this isn't a claim for money damages. This is a claim for declaratory and injunctive relief. And if their statute that requires notice actually says for damages, and we're not seeking damages, although we could have, we are seeking injunctive relief because we really want the LUEs and the development, not money from the city. Unless the court has any other questions that I'm happy to answer, I'll cede the rest of my time.
You'll have a few minutes on rebuttal if you wish. Thank you, counsel.
Thank you, Your Honor.
May it please the court?
Yeah.
Counsel. If the appellant's property was anywhere else in the ETJ, we actually wouldn't have this dispute or have this issue. The city's principal position is you can't take a micro part of a larger program and a larger system and only analyze a small piece. You have to look at it as a whole, just as you look at the acts as a whole. There is no state law that requires the city to extend its water sewer services outside of the ETJ, or outside of the city limits into the ETJ. If its ordinances make clear that if you have a residential development anywhere else in the ETJ, you don't get water and sewer services extended out there without being annexed. That's kind of the default, but that's also the backdrop about everything else that kind of happened in this case. This is also not a situation where we would be here if it falls under what I would refer to as kind of a pure subchapter K type of funding, meaning Water Code, Chapter 17, Subchapter K, because the purpose of that is to extend sanitary water and sewer to the home of an economically distressed area in the ETJ, which they have. The state funded those, and they have access to those. The reason we're here is because out of the 15 colonias, who we refer to as the original 8 in our brief, and the city asked the water board for permission to take the state-funded lines. So the state funded 12 inches of water line and 12 inches of sewer line, diameter-wise, and oversize it. So like with the water, it went from 12 to 16 inches, which means the original 8 in the city would pay for 4 inches. So they would pay for a fourth, and 3/4 was still paid for by state funds. With the sewer, it went from 12 to 24. they can't actually go in, the city couldn't go in and just do whatever it wanted with the lines. They needed the state's consent. The water board had to approve the oversizing part of that project. So what did the water board approve? Well, the participation agreement between the original 8 and the city was designed to get water board approval. They knew they would need water board approval, and so they were trying to address the issues that the water board would have. The water board, basically, the stated purpose for subchapter K has statutorily defined express intent. It is to extend sanitary water and sewer. It is also supposed to be done in a way that doesn't give an undue benefit to a subsequent developer. So if someone is going to come in, they need to be put in the same position as others in the ETJ. And so that's the entire concept of the LUEs on the first part, and that's for the funding for the line part and the additional capacity. The whole aspect, and the reason we're talking about LUEs, is because of the participation agreement has that as an essential term, but that's what the water board approved. Also, the water board, its regulations don't allow state funding to be used for anything other than houses, homes. So there's a residence-only requirement that's attached, and they have to be annexed. That's what the water board approved. Because if nobody else in the ETJ who's developing a residential subdivision can get water and sewer extended beyond the city limits without being annexed, if the original 8 were allowed to do that, they would get an undue benefit. And so that is a requirement. That's the only thing that the water board has approved. That created the program, the oversizing part of the program. And that's what the city started administering. They gave the city manager authority and discretion and the utility director authority and discretion to manage that program and ensure that the city complies with what the water board wants.
Council, how do you respond to the argument made by the opposing side that they were not part of the original participation agreement, and so therefore they're not bound by whatever was negotiated at that time?
They're approaching it from basically a contract standpoint. The thing is, to tap in and allow the oversizing, the water board has to approve it. The water board's approval makes it a program that has to be complied with. Those terms are what have to be complied with. When the original 8, they essentially prepaid for their LUEs. The city, by contributing, prepaid for LUEs. And so they were the only ones that were allowed to use the LUEs, the original 8. So when you fast forward several years, the city announced, okay, we have our LUEs, but we don't really own property out there. So we're going to sell our LUEs to the other 7, not anyone else in the ETJ, because really the LUEs only apply to the 15. That doesn't really change the program, because the program that the water board approved allowed the city to have those LUEs. They were just transferring them. So the city set the price that they would transfer them at and said, other 7 will sell you the LUEs. They already had a program in place. They already had a system in place. That's what they were administering. Changing that one piece doesn't change anything else in the way they're administering it or the program. If they were creating something different, something new, they'd have to go back and get water board approval, which they didn't do.
If I may, Council, and if it's okay with the panel, I'd like to see if you could move on to the rough proportionality test. Can you please share with us your position in terms of your response to Council arguing that there was no evidence of any impact to the city? Can you share with us?
Yes, Your Honor.
I'm going to ask if you could put a pin, because I have one question on
Sure.
this, if I
Absolutely.
may. Thank you. So the ordinances obviously extend authority to the city to do ABC. That included to sell the LUEs. In any way, did this authority in any way rescind or otherwise override any other provision or other ordinance, rather, that would otherwise expand the limited exceptions to the annexation requirement?
No, Your Honor.
None.
No, there are two ordinances that were passed in 2018, but they accept those listed as the exceptions under 31-3A, which include the colonias. So, and those were designed more to require annexation to be completed before anyone else in the ETJ. If they wanted to develop, they had to get the annexation done first before they could, get the water and sewer extended.
And even though the 2018 amendments weren't necessarily applicable, but because Consolidated's claims seek prospective relief, no objection to obviously considering the 2018 amendments.
Yes, Your Honor.
Okay. Yes, there's an objection or no objection?
No objection,
Very
Your
good.
Honor.
Thank you.
In the sense of, what
Sure.
does it actually apply?
Sure.
Yes, sir.
Yeah. Okay, then I'm done with that.
All right.
If you wish, if you remember.
Justice Rodriguez, for your question, our response is really kind of twofold. And our primary response I'll cover second, because I think that may be kind of what you're maybe looking at, though. The aspect regarding rough proportionality, the record actually does reflect, hold up, some of the record sections are going to be at 1250 through, I think it's 1256. We attached other annexations, other extensions that have nothing to do with the 15. They're in the other areas of the ETJ. They have the cost estimates that are attached to that. Our argument with regard to the fact that we have an estimate of what it would be, but it's only an estimate. They didn't start the process to find out the actual numbers or give the city the opportunity to kind of comment on what the real numbers are. There are several different ordinances that trigger the costs that they're not raising. And we gave an example where one of them, on the park dedication, it actually has built in an administrative process if the owner disagrees with the costs. There is a process built into that determination for that cost as to what it would end up being, and they have an ability to challenge it and go back and forth until an ultimate determination is made. The city never had the ability to do that at that point. Now, the cost aspect really is kind of they're trying to tie it into a rough proportionality analysis. The Chirac case, the Supreme Court's determination on it basically said when you're talking about this kind of case, you don't do the same type of analysis. The rough proportionality doesn't even apply when you're talking about this type of case. It applies when you're talking about a land use case. That's where the prodigy of it came out of. For this kind of case, it only applies if you're talking about a regulation that is so onerous it amounts to an ouster. That's kind of what the Chirac case ultimately ended up kind of holding. However, if you want to look at it through a rough proportionality analysis, we provided some estimate as to what the proportionality is. We don't think that kind of the exhaustion would apply if all we're talking about is their argument that there's no authority that says they have to be annexed. If that's the box we're talking about, the same type of exhaustion wouldn't apply. Because if there's no authority, there's no authority, right? We can go straight to that. But what they can't do is say, but if you do have the authority to make us be annexed, the cost is unreasonable. They didn't go through the full process to allow us to comment or get what the actual costs would be. Does that answer your question, Justice Rodriguez?
Yes, thank you very much.
Okay.
I have a question.
Yes, ma'am.
Regarding rough proportionality. So it is the city's position that Consolidated should proceed to voluntarily be annexed, right? The subdivision, just like the other developers did in the other 8, correct?
Our position is yes, they have to, in order to get the LUEs, they have to go through the annexation process.
So when we talk about annexation and whether it's roughly proportional to the projected impact of the proposed development in this case, do you agree that annexation involves a lot more than just water and
Oh, yeah.
sewer? I mean,
Oh, yes.
If they become part of the city, there's going to be a whole lot more that is included with that. So can you just address that in terms of rough proportionality?
This is much more, the element of annexation is much more about than just the water and sewer. We have to provide a full service plan. And the thing is, and they admit in their brief, the city has the authority to annex. If we're only talking about the annexation element, that by itself can't be a taking. Because all that doesn't seize their property, that doesn't deprive them of their property. It says the city limits extends over you, we can regulate you, we can tax you, but you're a citizen and you can vote. You know, so there's some balancing back and forth. They're trying to say the costs for annexation has to be roughly proportional to the request for water. And that's only, and sewer, that's only two of the services that have to be provided in the full scope of annexation. We have to provide fire protection, we have to provide police protection, we have to provide any other services at the proportional share to the rest of the citizens. And so it's mixing apples and oranges. If they're saying the rough proportionality doesn't equate to the water only. And does that answer your question? Sort of?
Sort of, yeah.
Okay. All right.
Thank you.
But we did provide examples of other annexations and other costs. We also noted that the way that what they're actually doing by not kind of going through the process. And we will note that until the annexation is complete, they can withdraw it. So they can allow the city the ability to determine numbers. But I mean, I get it. Their position is saying, you can't make us be annexed. So they don't want to do anything that makes it look like they agree that they can be annexed. Mm-hmm. And that's fine, but then they're kind of stuck in the box of saying the argument that doesn't require exhaustion is there's no authority to require us to be annexed. And that's kind of what they're stuck with at that point, because we haven't had the ability to actually determine the number. But the number for annexation, the way the Laredo has its ordinances arranged, the developer actually is given more control over what those numbers are, because it is kind of divided based on, you know, how many traffic lights they want to put in, what parks they have, whether or not the city's going to have to go out for extra water rights. And so it allows them to control their costs by making those adjustments in whatever or however they want to develop it. That's why the city doesn't necessarily get involved until later on when they're ready to start the annexation. So the city had the program in place. It was what was approved by the water board. That's what they were managing. They only changed one element. It wasn't even really a change. CTH comes along and has filed suit. It's important to note, though, that what is it that they're suing for? They have a variety of different causes of action that approach the same end from different angles. Their end, the relief they're asking for, they're pretty blunt about it in the petition. They want a declaration from the court that the city has to sell them the LUEs, has a ministerial duty to sell them the LUEs in the ETJ, extend water into the ETJ, and can't require that they be annexed, which nobody else gets. Not the original 8, nobody else in the rest of the ETJ. The purpose of subchapter K states that it includes an intent that a subsequent developer not get an undue benefit. The city's assertion is essentially that by allowing them to stay in the ETJ and forcing the city to give them water and sewer that nobody else gets, that's an undue benefit. That's why that was a requirement in the participation agreement, and that the water board approved, that was part of what they had to do to use the LUEs, to get and use the LUEs. So all of the things that occurred, all the statutory construction principles that we look at have to take that express intent in mind and to be interpreted in a way that allowed that express intent to be accomplished. What their end result is flies in the face of that. From the city's perspective, that would kind of end the analysis right there. But the trial court had a lot of additional grounds in order to rule against CTEH and for the city. The statute of limitations elements are already kind of briefed. We're not talking about a 10-year because the 10 years comes from the elements of adverse possession, when you're like physically taking the property or you're kind of cutting it all off. One of the cases that they cite for the premise that depriving them of utilities can amount to the 10-year statute was actually the Houston Court of Appeals opinion in the Chirac case that the Supreme Court overruled. That Supreme Court didn't overrule it for that purpose. It basically said, we don't even get there. That's not the kind of thing that can constitute a taking. They found out that annexation was required in 2017. The ordinances were passed in April and May of 2018. They didn't bring suit until August of 2020. The ultra vires element, well, you're telling a public official you have to come into compliance with state law. You've exceeded your authority, or you're not performing a ministerial duty. You must. They have not pointed to any state law or city ordinance that says we must sell them LUEs or that we must extend water and sewer outside of our city limits. The statutes and the charter vest the city manager and the utility director with the authority to manage this program, and what better way to make sure they're complying with the rules that the water board has than to use the standards that the water board already approved. That was within their authority. The remaining defenses are there, but I think I've covered the main ones and the strongest ones from our perspective. What they're asking for doesn't actually, isn't allowed when you're taking to effect what the benefit the developer would get out of that. We believe the trial court's judgment is accurate and correct, and we believe it should be affirmed. Thank you. Any other questions? Oh.
Your Honor, one of the points made was that other areas of the ETJ wouldn't be able to receive water and sewer, and that is correct. But we are within the original 15 colonia areas that were to receive water and sewer services. So the argument that somehow these other people were not given the same opportunity, or that their costs or that their ability to receive water is different from ours, is a matter of the state's funding and the law, not the city's discretion or anything else. The second is they say you should look at everything as a whole because annexation requires them to provide other services. But annexation is the requirement that they're giving to us. They're saying you have to voluntarily annex. It's not what we're objecting to having to do that. The problem is they're not selling us LUEs. And that's completely different from annexation. They had the power to annex us, but they don't have the power to force us to voluntarily annex and pay all those fees, which is what they're doing. It's a fee generation operation, nothing more. Finally, they said they're not required to provide water and services to the colonias. That's not correct. They have the CCN, the Certificate of Compliance and Necessity, I think, that requires them to provide water and sewer to this area. So it is their duty to do so. They have an affirmative duty from the state to do that. Next, they said the water board approved the requirement that they annex property. That's simply not correct. There's nothing in the record that shows that. The water board approved their contract with the 8. They didn't say that those were required in the future. They didn't say those were the standards. They simply noted that that was their agreement with those 8 original landowners. Next, the 8 original landowners, there's not even evidence that they ever annexed or, did anything to develop their property. There's nothing in the record about whether or not these 8 did. They're assuming they did, But there's no proof of that whatsoever.
So,
Is it-
oh, I'm sorry.
Go ahead, please.
Counsel, I just was going to interrupt you there. So is it your position that Consolidated does not have to follow the requirements of everyone else in the greater area?
Not in the entire ETJ, no, because the Colonias were given special permission by the state by virtue of this project to receive sewer and water. That was the whole point of it, of the 16 million. It was to provide sewer and water to these areas.
Do you think that could be seen or interpreted as an unjust benefit to the developers?
To the developers of that area from the state's money? No, Your Honor, because the question is whether or not giving us those benefits somehow is an undue benefit to us as one of the developers. So no, not at all. The question
Let me
about...
follow up on that.
I'm sorry, go
So-
ahead.
So the city's general rule is essentially that annexation must occur before they allow water rights, or water services rather. And there's exceptions to this rule that were allowed in 1995 as part of a state initiative, right? To
Correct.
provide water services to economically distressed areas. These exceptions that the statute provided were limited to just existing residents, right? And a relevant code which is referred to by the justice, the provision that stipulates, quote, "It's the intent of the legislature that a private developer not unduly benefit from the expenditure by the state of public funds on infrastructure for the public benefit." That's under the water code. So 8 colonias that we referenced, and they sought future development, and they agreed to annexation.
In the participation agreement, not as part of the project.
Well, but they agreed to annexation.
They did.
Okay.
And they
I'm sorry.
specific-
The key takeaway, I think, from what you want is to show that, hey, this annexation doesn't serve a legitimate purpose. Under these unique circumstances, though, is there not a different view in the sense that under these unique circumstances, and the harm to colonial residents that would come justified an exception to the annexation rule under the terms of the funding under state law?
I don't understand what harm would come to the citizens of the colonias, Your Honor. So I don't entirely understand your question. I apologize.
Well, again, as I noted, the legislature showed under certain circumstances, particularly in these EDCs, they don't want to have a developer unduly benefit when it can cause harm, okay? And under the unique circumstances of these 8 colonias, did it not fit, under those unique circumstances, fit under that province, under the legislative intent, that's a different view of what might be seen under the unique circumstances that happen for the 8 colonias, which you're looking at it differently. You're seeing it, hey, there's no legitimate purpose.
I'm also saying there's absolutely no proof that those 8 were treated worse than my developer, CTEH, because...
Is that necessary?
Yeah, absolutely.
Under the
because,
general rule of authority by the city to require annexation to provide water services?
Yeah, because that doesn't... Requiring voluntary annexation doesn't apply to us, because that in statute wasn't enacted in 2018. We applied long before that for this provision, and you can't retroactively enact a statute and then say suddenly it applies to your former application for OUEs.
This was an exception provided under the 1995 statute.
No, nothing in the 95 statute required annexation.
Okay, the 1995 provision under the water code.
Right.
Which I
Nothing requires
referred to.
annexation.
Very good, thank you.
The idea that we had to have no value or ouster from our property in order for it to be an improper exaction, simply not correct. The law is completely contrary to that, as is a requirement that we apply and go through with the annexation before we can challenge it. That's contrary to U.S. Supreme Court and Texas Supreme Court law. The estimate that they talk about as for their proof was an estimate of what it cost other people to annex their property. That's not the test. The test is what it costs us versus what burden it added to them from our development. And there's zero evidence of that. And for that, they can't meet the test whatsoever. Even if some kind of burden were different, they have to show that it's unduly burdensome. Those original 8 paid $800,000. Let's ignore the fact that they could be different size plats and different costs for the services to be provided. That would be about $100,000 a piece. They're asking us to pay $250,000 just to get to pay the LUEs, which they say the 8 landowners were prepaid for, if I heard correctly during their argument, that they prepaid for their LUEs. Assuming that they were annexed as part of that, and there's no proof that they did or that they developed the property, ours is still unduly burdensome as compared to them, not the other way around. But the water board simply did not approve that. We're not asking them to sell it to us because they have to, because it's a ministerial duty. We're saying they can't condition the sale the way they have because it's not required and it's unconstitutional. Finally, I think that the 10-year statute, I believe there are a number of cases that say that regulatory takings like these are governed by the 10-year statute of limitations, not the 2 or 3 year statute of limitations. I think that's about everything that was addressed in Appley's argument, unless the court has any further questions.
Any questions?
Can you address again, and I know you did this when you first came up, the rough proportionality part of the two-prong test?
Yes, Your Honor. I just don't think that there's any evidence of what impact our development is going to have and what cost and burden it would cause the city in any way. They just say it's unfair and that it was required. They never actually went through the steps to make any kind of proof of what the burden would be to them of that requirement. So I just think they failed proof-wise.
Very good. No
Thank
further
you all
questions.
very much,
Thank
Your Honors.
you. Your case has been submitted and an opinion will be forthcoming. Court is adjourned.
All rise.